This is The Guy Gordon Show on News Talk 760 WJR.
So what would an Executive Order 2.0 look like in terms of these travel restrictions? And there is understandable concern about this in immigrant communities with loved ones that were scheduled to come into this country, and thank goodness from their perspective that can still happen with the stay not given last night by the Ninth Circuit. But the president hinting that yes, he will appeal that ruling, but they will also offer something else up on Monday. If it is a new executive order, what needs to be done to fix the overly broad aspects of the original order, which have caused so many districts to see the flurry of lawsuits. We talked about that with Byron Henry, a Dallas-Fort Worth attorney and constitutional scholar. Mr. Henry, the president kind of intimated in his press conference with Prime Minister Abe today that something big was going to happen on Monday. If that is the redrafting of an executive order, what does he need to do to satisfy the Ninth Circuit and the 10 other districts where this is under attack?
Well, the first thing I think would be smart is to go ahead and take what they've already made clear through the White House counsel's office, and that is that the executive order does not apply to permanent lawful residents or green card holders, which was a major anchor of the Ninth Circuit's decision that those individuals have constitutional rights that could be violated by such an order. So the first and most important thing I think is that it should make clear that the executive order does not apply to lawful permanent residents or green card holders. That's number one. Secondly, he could go ahead and separate the other classes of aliens and explain how it applies to them, such as refugees, asylum seekers, visa applicants, and visa holders. There's a number of classes of aliens, and instead of just putting them all into one travel ban which sweeps them all up into one order, he could go ahead and, if he's going to do it again anyway, go ahead and specify each class and how the order affects that class of aliens. Because
then at least with each class, there would be the measure of confidence that you're at least marginally making the country more secure, and you wouldn't throw the whole baby out with the bathwater then.
That's exactly right. And if you read the Ninth Circuit's opinion, it's pretty clear, besides some legalese and procedural issues on standing and some other items, that the main concern was this order is so broad, it might affect constitutional rights of some of those affected by the order. And because the government couldn't prove that it would not affect anyone's constitutional rights, the stay remains in place. So the real issue here is making sure that the Ninth Circuit or any court that reviews it can look at it and say, okay, here's this class of aliens, what's the president's authority by Congress and constitutionally. Here's this class of aliens. Here's this class of aliens.
Right.
And so you can do it piece by piece, which is a cleaner way and a more specific way of doing it. And that way it's kind of like a menu that the Ninth Circuit or any court can go down and say, this class of aliens not protected, this class of aliens not protected, this class of aliens is protected, and therefore they're entitled to due process. And they can sustain the executive order as to some classes, even if they have a problem with it as to others.
And you get the classic half a loaf is better than none. So moving forward, if the Trump administration does bring out a new executive order on Monday, is there a need, and if they get most of what they want into that executive order, and a much less sloppy executive order than the original one, do they need to appeal this Ninth Circuit decision, or do you just leave it be, since it really did not challenge the president's authority to do this? It merely talked about the stay.
I mean, legally, as a lawyer, I would say no, there's no need. It did not affect the president's authority. All it did was talk about the government's burden to get a stay of the district court's ruling. It was very broad language by the Ninth Circuit in this motions panel. It wasn't a decision on the merits. But politically and optically, I think the president wants to get it decided early in his presidency, whether it's at this court or the Supreme Court level, that he intends to exercise the discretion Congress has given him with respect to immigration, and he wants that settled. So in that respect, a new executive order might boot the entire case, so there may not be a choice for him to continue to fight. But I do believe that the executive, the president and his Department of Justice, want this issue settled early with the court, so they don't have to go through this every single time they make a move on immigration.
Right. There are some analysts that are suggesting that this Ninth Circuit order extended constitutional rights to people that normally would not have them, well beyond the bounds of the green card holders, the visa holders, or those that have a right to be protected under the Constitution for due process, which was the tipping point issue here. Did you read it that way?
Well, I can tell you very sly the way the Ninth Circuit went about their ruling. First of all, they discussed lawful permanent residents and people in the country who we know have constitutional rights. There's Supreme Court case law on that. And then they just threw a catch-all paragraph about others that possibly might have rights.
Exactly.
There's no authority for the basis that if you're not in the country, typically here, or a green card holder that has the right to reside here permanently, that you have any constitutional rights. If you're not in this country and you're over in Syria, or you're in any other country and you're a visa holder, or you're an applicant, or you're a refugee, or you're an asylum seeker, there's no basis to hold. And they didn't hold this. They said it is possible that the government didn't show that they absolutely did not have constitutional rights. Not the opposite burden, which would be the burden on the merits, and that is that they do have constitutional rights. And once you take those lawful permanent residents and people here in the country off the table, it is going to be very difficult for a court to find that those other classes have constitutional rights.
But that text, if it is in this order, this ruling, should that be challenged on appeal, if only because of that possible scenario, which is so nebulous and seems to create a new extension of rights to people that otherwise would not have them?
I don't read it that way. The Supreme Court has held with respect to due process rights definitively with respect to lawful permanent residents and others, and I don't believe this changes the law. All it did was throw out a paragraph saying there may be some rights affected by this order. It did not hold that any of those classes actually have due process rights. Had it done so, then I think the president would be forced to appeal it to correct the law. That would be the law in the Ninth Circuit. But because it did not actually hold that, and it just postulated that it's possible, I don't believe it's necessary. I don't believe it extends the law, and therefore not necessary for the president to appeal it for that sole reason.
And finally, Byron Henry, would this ruling have come down as hard as it did had the administration not challenged this based on their view that this was a quote-unquote unreviewable decision? Wasn't that in essence like poking the bear, and was that a wise avenue?
Yes and no. What I think the administration did sloppily was draft an overbroad executive order and then have their lawyers argue it was unreviewable. I think the case law supports that the reasons for the president's order are unreviewable, meaning the government doesn't get to test the president's decision that something's in the national security. But the order itself is, of course, reviewable under the Constitution by an Article III court. So I think it was a misstep to basically say that the issuance of the order was unreviewable. And what I think they meant to say and should have been clear about is that when the president decides something is detrimental or a security risk, a court is not allowed to look behind the reasons behind the order. And that I do believe is unreviewable. But I do think that played a part in the court's decision here. The 3-0 nature of the decision
right.
is that they wanted to make clear that the courts have a role to play. And I've said this numerous times. The courts have a role to play here under our structure. The problem is in national security and immigration issues, the starring role goes to the president and Congress, and the courts are a backup role or a supporting role that's supposed to give deference to the president on close calls. And unfortunately here, I don't think anyone would argue this isn't a close call, and normally courts would give deference to the executive on close calls.
All right, Byron Henry, thank you so much for your insights today. You have a great weekend out in Dallas, and look forward to talking with you again.
You too, my pleasure.